Welcome everyone to this webinar on determining international or national fair shares and within a framework of international environmental law. Thanks for joining. My name is Niklas Höhne. I'm working at the New Climate Institute, and I have the pleasure to introduce to you a very distinguished panel here. First of all, we have been writing this paper, which we want to introduce here today, together with Lavanya Rajamani from Oxford University and Louise Jeffrey, also from the New Climate Institute, and a few other co-authors. But these are here right now. And we also are very happy to hear, after the presentation of this paper, the comments from Lucy Maxwell, who is at the Climate Litigation Network, and also from Gary Liston from the Global Legal Actions Network, to give us their comments on what they think about the paper and what the next steps could be. As we've said, this is about a paper that is available on climate policy, which is a research journal. It's open access. There's a link at the bottom of your screen, which you can see, which you can click. And then you get right away to that paper. It's about national fair shares in reducing greenhouse gas emissions within a principled framework of international environmental law, which is the interesting bit about it, which is basically looking at emission reductions, more the quantitative side of things, and the side of international environmental law court cases. So that makes it very interesting. I think I would now we want to present this paper and then have the two comments and then have an open discussion. You can already now think of questions. At the bottom of your screen, you see an Ask a Question button. If you have a question, you can already put it in there. All the others can see those questions as well, and they can vote if they think it's a good question. And the questions that have the most votes, well, they will bubble up. And we can then take them one by one after we've gone through the introduction of the paper and the comments on it. All right, great, thank you. Then we start, and I will actually say a few words about the background of this paper. As we said, it's in climate policy, it's open access, you can read it. It's a large set of authors here, led by Lavanya and the other names that you see here on the screen. If we move to the next slide, then you can see why we are doing it, or what our idea was to do it. There's a big question in the international climate negotiations on who should do what. Which country should do how much? And while it is clear that under the Paris Agreement, every country should provide a fair contribution, it's very unclear what that fair contribution is. And there have been quite, on the more natural science side, there have been quite a lot of groups calculating what could be a fair share contribution from each country, taking different norms, taking different criteria, indicators that could describe that a country is doing a fair thing. And they have been quantified, and they come up with ranges. But what then has been done is that these numbers that have been generated more on the side, on the natural science side, they have been used in court cases. And checked whether countries have actually reduced their greenhouse gas emissions or are planning to reduce their greenhouse gas emissions in line with these numbers. But what has been missing is whether the arguments for either putting forward such a target or calculating such a target, whether they actually stand principles of international environmental law. That hasn't been done. And that's why we came up in this paper to basically do two things: the quantification, or the natural science side, and do that together with a close look of principles of international environmental law, and to check whether we can put the two together and come up with a determination of what's a fair share on the basis of these principles of international environmental law. And this is so important, as I said, because it can be used as a benchmark for countries to set their targets, but it can also be used for those that are planning for litigation cases to have good arguments at hand to say, well, this country is probably not doing yet as much as it should do. So much for an introduction. Then I would hand over to you, Lavanya, to introduce us to the principal framework on international environmental law. Over to you.
Thank you, Nicholas. What I'm going to do in the next 5 or 7 minutes is to take you through the method that we use to answer the research question that Nicholas has identified. To what extent are fair shares to be determined on the basis of international environment law, and how do we do those? And I will also speak briefly to these principles. Of course, given the fact that we only have 5 or 7 minutes to do this, I will not be able to dot all the I's and cross all the T's, but we're happy to sort of discuss this further in the Q&A session. And also, of course, you have access to the paper itself, which does dot all the I's and cross all the T's. So in terms of the method that we used to answer this research question that Nicholas identified, we reviewed 167 NDCs, which includes the EU's NDC, submitted until the end of March 2021. So it includes all the updated NDCs as well that were submitted until then. And we tabulated references to principles of international environmental law. And in some cases, these principles were explicitly identified as principles in the nationally determined contributions. And in other cases, aspects of the principles were referred to, and we tabulated those as well because these were implicit references to the principles. We also identified and tabulated all the objective indicators that states had listed in their NDCs and through which these principles are actually operationalized. We tabulated, in addition, references to progression, highest possible ambition, and best available science. These are terms drawn from the Paris Agreement, Article 4.1 and Article 4.3 of the Paris Agreement. We also tabulated references to the long-term temperature goal in Article 2.1 of the agreement, well below 2 degrees centigrade and with an aspiration to reach 1.5 degrees centigrade. We also tabulated references to human rights. So this is an extensive database that we put together. We tested the indicators that states had identified against the principles of international environmental law, and I will speak in a minute to what these principles are. We identified principles that are not anchored, indicators that are not anchored in principles of international environmental law, and we excluded these indicators in our quantification of what the fair shares should be for states. We then narrowed this range of fair shares based on further principles of international environmental law and the normative pillars of the climate change regime so as to reach the global temperature goal. And I will flesh out each of these steps of our analysis in a minute. So what are the principles of international environmental law that we refer to in our paper? A whole range of them, from harm prevention to precaution, to the common but differentiated responsibilities principle, which is a very fundamental part of the climate change regime, to good faith international cooperation, equity and sustainable development. Next slide, please, Louise. Now, the core content of each of these principles varies. They obviously deal with different content. And within each of these principles, there's an interpretational range. So for instance, the common but differentiated responsibilities principles, there is a range of interpretations of that which have been put forward and advocated within the climate change regime itself. The formal legal status of each of these principles also varies. So for instance, the harm prevention principle is recognized widely as customary international law, whereas some of the other principles are at best soft law. The operational significance of each of these principles also varies. So for instance, the common but differentiated responsibility principle has huge operational significance in the climate change regime, but it is not a principle of customary international law. So one of the findings for our paper and more broadly is that there is tremendous operational significance to some of these principles, and they're salient even if they do not have formal legal status as binding. So the functions these principles perform is to form a fundamental part of the conceptual architecture of international environmental law, and they create a very strong directional pull in terms of where and how the interpretation should be. Next slide, please, Louise. So why did we tabulate these references to principles in the nationally determined contributions? For a range of reasons, but perhaps most significantly to underscore the fact that states themselves think of these principles as the basis for the climate change regime. That and this is important because the climate change regime has often been touted as a sort of a pragmatic, realpolitik sort of regime, which reflects to some extent the dysfunctional politics between states. But actually states themselves refer to these principles in their nationally determined contributions, and that is something that then drives our interpretation of fair shares. Next slide, please. So we divided them in international environmental law principles into 3 buckets. Those principles that are relevant in determining fair shares, those principles that are relevant in interpreting fair shares, and those principles that are relevant in actually implementing fair shares. So in relation to the principles that are relevant to determine fair shares, the principles that we have placed in this bucket are principles of sustainable development, special circumstances or vulnerability, common but differentiated responsibilities, and intra and intergenerational equity. So there are indicators associated with each of these. So for instance, common but differentiated responsibilities, historical responsibility, emissions per capita, GDP per capita. These are indicators that help us operationalize the principle of common but differentiated responsibilities. And similarly, there are indicators associated with the other principles as well. The next slide, please, Lewis. On the basis of our analysis, we then identified the indicators that states have states have referred to in their NDCs, which are actually not anchored in principles of international environmental law with respect in particular to determining fair shares. So for instance, many states refer to the fact that their contribution to the global emissions is a small share of global emissions. But if we looked at and added up all the emissions that these countries who claim that their emissions are a small share have actually contributed to global emissions, it amounts to 1/3 of global emissions. So not just is it not a relevant factor, it is actually a problematic factor in a sense to determining fair shares. Least cost pathways, similarly, the fact that a particular target is based on least cost is relevant in relation to implementing a particular fair share that a state has taken on for itself, or a target a state has taken on for itself, but is not relevant in determining what that fair share is. And there is no basis in international environmental law for any of these indicators to be taken into account as relevant in determining fair shares. So on the basis of this analysis and excluding these indicators that are reflected in our on the screen, we then quantified national fair shares. And I'm now going to hand over to Louise.
Thanks, Lavanya. So I'm getting a little bit of feedback. Oh, not all good. Thank you. As Lavanya has just described, we divided these principles into 3 buckets. So the determining principles, the interpreting principles, and the implementing principles. And what we find is when we essentially do our quantification of emissions reductions based on the determining principles, we find that you can get very many different interpretations for an individual country, which leads to a very wide range of possible fair share reductions. And this leads to the challenge then that if all countries were to pick the top end of their range or the most favorable target for themselves, we would end up with such a high range of total emissions that we would not be in line with the Paris Agreement and with the temperature goals that we've set. So we therefore need a second step to determine, well, how do we compress this range or identify where we need to be within that range to actually meet the goals that we need to do. And this is where we then incorporate these principles that then interpret the fair shares. And these principles that we use are those of harm prevention and of precaution, but also the normative pillars of the climate change. So the overall objective of the climate regime, then also principles of progression between subsequent targets, and the trust in each other that are putting forward through highest possible ambition. Based on all of these principles, we can then argue that a country should not just pick the most favorable target to itself, but rather to push itself down within the range and in a fair way across all countries, such that we end up with targets for all that, when added up, actually achieve the objective that we've set. And I'll show you in a couple of moments what that actually means in a quantitative sense. We've also alluded to principles that are relevant then in implementing fair shares. So once we've actually set fair share targets, we find that some are maybe more stringent or more ambitious than maybe that may be realistic, especially if you look at economic situations. And there we need to build on other principles in which to actually implement these fair shares so that all countries are contributing their fair share. And the first of these is cooperation, and this can be realized in many different ways. There's cooperation in terms of finance, in terms of capacity building, in terms of knowledge sharing. At the national level, it's also really important that the fair share is implemented in with public participation. We need to establish good ways that incorporate the entire societies in terms of actually implementing fair shares and in implementing domestic mitigation targets. And finally, all this needs to be done in good faith. So in good faith that we trust other countries, other nations, other bodies to actually implement and be as ambitious as they can be towards implementing the actual Paris Agreement target. What I'd like to do in the final few minutes is to show you some of the results of our more quantitative analysis. So Lavanya described both of these at the start. And the first of these was to look at the NDCs and see how they reflect these principles and the indicators that we've identified as a bit of a back and forth exercise that we had. What you're seeing here in the colored boxes, so the green, purple, orange, are the different principles. And the numbers are indicating how many NDCs that we found that actually mentioned these different principles. Within the white boxes sort of nested in there are the indicators, and again, the numbers indicating how many times these were reflected in individual NDCs. What we saw is that particularly sustainable development and special circumstances were mentioned an awful lot. Also, emissions per capita in terms of equity were the most commonly identified indicator that we saw. It is worth noting that, as Lavanya said, for example, we had 111 countries noted that they had a small share of global emissions, which is really quite a lot, but also some of these other indicators that we identified as not being consistent with the principles that should be used for determining fair shares. So there is some consistency, but also some discrepancy with what countries see for themselves. We also looked at those principles that form the basis of interpreting fair shares and implementing fair shares. Not so many highlighted or alluded to those interpreting fair shares, although harm prevention was mentioned by some. Whereas principles of international cooperation and public participation were either directly or indirectly alluded to in a large majority of the different NDCs. But what does this all actually mean in terms of what countries or governments need to be putting forward and in their NDCs? And this is the last step of our analysis, is we take all these principles and try to convert those into quantitative targets for the individual countries. And we've actually done this analysis for all countries, but I'm showing the results here for just the G20 countries. Now, this is a somewhat complex plot, so I'll take a couple of minutes just to explain what you're seeing. So the y-axis here on you're seeing is percent of 2010 emissions. And for an individual country, we're showing this bar that reflects, or the full range of this bar reflects all possible interpretations of fair share that we found in the literature and through our own calculations that we then brought together. But through these various different principles, we're able to then narrow that range somewhat. So if we look at, for example, the case of India, you'll see the grey ends to the bar. And these are essentially arguments of fair share that we were able to remove for our analysis based on the fact that we did not see them as consistent with the principles. So grandfathering, or in the case of the United States or Japan, these are often least cost based analyses that we were then able to remove. But as we said before, this is still a very, very large range. And if all countries were to hit the top of their range, we would overshoot our target by a very long way. So we need to then reduce the target. And what we've done is to essentially go down each bar by the same amount until we hit a level at which, when we add it all up, we are consistent with a more ambitious target in line with the Paris Agreement. We're actually showing two here. The top of the hashed blue range is identified by the UNEP GAP report as holding warming below 1.8 degrees with 66% probability. But you could argue that we need to be even more ambitious than that. And the UNEP GAP report also have scenarios and emissions levels in 2030 that keep warming below 1.7 degrees throughout the century with 66% probability, and then are then below 1.5 in 2100. What does this actually mean for countries? Quite ambitious emissions reductions. So you'll see, for example, Germany, the EU, UK are negative. So below zero means actually negative emissions by 2030. A few other developed countries would need to be around zero by 2030. So Italy, Japan, the US. I think important to highlight is that it really means emissions reductions for almost all countries. We have a couple of exceptions here. Indonesia and India might be allowed an increase in emissions since 2010 under a fair share principle, although that might not be consistent with actually getting to 1.5 degrees. But Indonesia has already overshot that, and relative to today would need to even decrease emissions. There's a lot to digest there, and happy to discuss in more detail, maybe some individual country results. But I think also that this framework of principles is hopefully helpful then to discuss the basis for building on this further. I'd like to hand back to Nicholas, who will continue our discussion. Thanks, Nicholas.
Yeah, thanks a lot, Lavanya and Louise, for introducing the paper and the inputs. To this, as you can see, it's, I think, a super interesting piece, because it's the fundamental question of the international climate negotiations: who does how much? And we haven't really solved it, and we haven't really solved it in the negotiations. But another way to solve it could be through litigation, and that's why we have two users of this information with us today, who are specialists in climate litigation. And I'm super interested to hear your comments on what you think of this, what you can make of it, and what more information you need, if this is enough, probably not, what more you need to do your job right. Let's first go to Lucy Maxwell from the Climate Litigation Network to give us your perspective. Lucy.
Brilliant. Thanks, Nicholas. And it's wonderful to be here today at the launch of this really important report, which I think couldn't come at a better time as we are heading into the Glasgow COP26 negotiations. So as Nicholas mentioned, I work at the Climate Litigation Network, which is a project of the Urgenda Foundation, a Dutch sustainability organisation that successfully sued the Dutch government for inadequate mitigation effort. And that was the first time back in 2015 that a court had ordered a state to ramp up its mitigation ambition because the state was not doing its fair share. And that was based on effort sharing evidence that Urgenda put forward. So I'll talk a bit about that case and explain a bit about the kinds of litigation that's happening around the world that's relying on the very kind of evidence we've heard about today. And in particular, I'll highlight three new contributions that this report makes, which will be very helpful to the kinds of climate justice efforts that are happening around the world. So a bit of background to our work, which explains the kinds of challenges that are taking place. At the network, we work with communities and lawyers around the world to bring cases against national governments in relation to their overall mitigation efforts. So it's quite a specific type of climate litigation that looks at the overall emissions reductions of a country. And those cases tend to focus on global north governments because of their heightened historic responsibility for the climate crisis and their capacity to mitigate. So you see in the report, there was a focus on where the G20 countries should be, and that's very much where the kind of climate litigation that we do is focused. And defining a country's fair share of emissions reduction is a central part of these cases, because what the plaintiffs are putting before the court is the country's current NDC or mitigation plan, and then objective evidence based on best available science and national law informed by international law about where the mitigation target and the efforts should be, and to demonstrate that gap. So having a report like this is absolutely crucial, because that's one of the key benchmarks or standards that communities can put before a court to indicate the huge gap that remains between where the state is and where it needs to be to prevent dangerous climate change. But before turning to the report, I'll just give a very brief bit of background about why communities are turning to the courts and what kinds of standards on fair share they've been using, and then how the report will add something quite different. So very briefly, we know that in the last couple of months, there's been additional warnings about how far states are falling short of the kinds of emissions reductions needed to hold temperature increase below 1.5 degrees. In September, the UNFCCC indicated that based on states' current pledges, we would see emissions increase by 2030 globally by about 16%. Now, we know that a most conservative estimate is that globally emissions need to be reduced by about 45% by 2030 if we have a chance for 1.5 degrees. So we are completely off track. And just last week, the International Energy Agency reported that for all the commitments that states have made around net zero emissions, the action that's needed to make those commitments true is not there. And that by 2050, we're looking at only an emissions reduction globally of around 40%. So nowhere near the net zero that states have committed to. So it's this stark gap that we know that communities are responding to in a number of ways. There's school strikes and advocacy and pressure in the lead up to things like COP, and climate litigation has one important role to play. And that's particularly in relation to putting scientific evidence and states' legal obligations before a court, so that it takes states' mitigation efforts out of the realm of politics and policy, and it holds them to account against objective standards. And I'll briefly now talk about the kinds of standards that claimants have used so far to define a state's fair share, and then what this report offers. Briefly, the climate litigation landscape in the last 5 years, since that landmark Dutch decision, has really exploded. We've seen communities from Colombia to Ireland to New Zealand, throughout Europe, in Latin America, assert based on states' human rights obligations and their obligations to protect people within their jurisdiction under civil law or tort law, that states are not doing enough to protect people from dangerous climate change. And they're pointing to evidence like the reports of the UN Environment Programme Emissions Gap or the UNFCCC report, and saying, globally, we see we're falling short. But for a case against an individual government, you also need to be able to say what that state should be doing as an individual country. So I'll take you through some of the standards that plaintiffs have been relying upon so far prior to this report. So firstly, looking at the Dutch decision in the agenda case, which was the first one that was successful in doing a fair share style case. There, the claimants, it was filed in 2013, so things have moved on a lot since then. But back in 2013, the plaintiffs were able to rely upon an analysis of effort sharing, so an analysis of all the papers that look at how to split the global carbon budget, that was included in the IPCC's AR4 report. And that report had said, based on all of these papers, for a developed country to hold global temperature increase below 2 degrees, which back then was the standard, there needs to be an emissions reduction by 2020 of between 25 and 40%. So that was a range that was included in the paper, and it was in the IPCC, and it had also received political recognition because COP decisions had referred to that. And that was the standard that the plaintiffs in the Dutch case used to define the Netherlands' fair share, that it needed to be within that range of emissions reduction. And it was a 2020 case, so that's what they were using. And the Dutch courts accepted that while there aren't cut and dried answers about a state-specific fair share, this was a standard that had scientific backing and evidence and had been recognised through the international climate law negotiations. And on that basis, the court accepted that it was a relevant standard for it to consider. The state fell below that standard. And on that basis, the state was ordered to do at least the minimum of that range. And we've seen since then that in other court cases around the world, which are now more focused on 2030 ambition, claimants are using evidence like the finding in the IPCC special report for 1.5 degree, that there needs to be a global reduction by 2030 of about 45% to hold temperature increase below 1.5 degrees. And that's quite commonly used in litigation to define a country's fair share. So at least that much. And we've seen courts have been willing to engage with these questions. And in the past 2 years in particular, it's not just the Dutch courts now that are accepting that these cases are appropriate and are able to be adjudicated. But this question of fair share has remained a bit of a stumbling block in a number of different jurisdictions, that courts have been willing to say there is indeed a legal obligation to mitigate and individuals can bring a climate case. Courts still, we've found, they need as much evidence as possible to determine what the state should be doing. What are those objective benchmarks to determine that the state is not doing enough to mitigate? And here now, I'll conclude by highlighting the three aspects of this report that are particularly important and that we haven't had so far to put before a court. The very first thing is what we've heard already this morning, that this report combines legal principles that states have signed up to when they have ratified the Paris Agreement, ratified the UNFCCC back in the early 90s, and it provides a legal basis for the question of splitting the global carbon budget. And it clearly indicates that some of the methods that states might choose to rely upon to determine their own fair share are not in fact consistent with the treaties to which they have signed up. And that's crucial. It combines law and science, and it says there are legal principles against which we can assess a state's definition of its fair share. That's the first thing. The second thing is that the report enables communities to determine an individual country's fair share. So far, what we've had is ranges that have been sometimes proposed at a global level or for developed countries, but never at the level of a specific country. And that's crucial when you have a case against a national government. You want to be able to say, this is what the literature indicates is your responsibility. And finally, this report indicates not only whether a state's emissions reduction falls within its fair share range, but it does that next step, which was what Louise talked about, which looks at the sufficiency of that emissions reduction. And it prevents states cherry picking the most favourable interpretation of equity for them. And it requires that if every country adopted such an approach, would it meet the global temperature goal that everyone has signed up to? And that's the step that we call, I think the paper calls this, the equal level of ambition test. And that's absolutely critical because we know climate change is a global commons problem, and states need to be looking to each other to think, if we were to adopt such an approach and others were to follow, what would happen? And so that's the third contribution of this report, which adds something quite new to the literature on defining a state's fair share. So with those three things added to our body of evidence, I think it's going to be fascinating to see how new cases are developed, cases are filed that rely on this, and it's precisely what is needed to successfully challenge these inadequate mitigation efforts in court. And so I'll leave it there. Thanks.
Excellent, Lucy. Thanks for your insights there. And it's really good to hear that you have at least these three elements that are new and that are helpful for your work. And I think that's probably similar to what you are going to say, Jerry, from the Global Legal Actions Network. Jerry.
Indeed, and thanks very much, Nicholas. And I'm extremely grateful for the opportunity to participate today in the launch of this paper, which, for reasons I'll briefly explain, is extremely helpful to a case that is currently pending before the European Court of Human Rights, which we in the Global Legal Action Network are supporting. Just a very brief overview of the case. It's brought by 6 Portuguese children and young adults against 33 European countries. And essentially the case argues that the respondent states are not doing enough to reduce their emissions, as is required to hold global warming to 1.5 degrees, and therefore to protect a number of the applicants' fundamental rights. And like in many of the climate change cases that Lucy mentioned, the question which arises is how much is enough? And of course, the fair share issue is a central part of this question. Now, it's worth just mentioning at the outset, without naming all of the respondent states, that they are quite diverse from an equity perspective. So, for example, we have among the defendants quite wealthy countries with high historical emissions, like the UK, for example. And we also have countries with a much relatively lower financial capacity to mitigate and lower historical emissions, like Ukraine, for example. And that diversity itself raises a challenge, because if we were to pick just one measure of equity as the basis for our case, it would inevitably be a relatively more stringent measure for one group of countries and a less stringent measure for others. So that's one of the reasons we have opted to base the case largely on a fair share range, as in the Dutch agenda case that Lucy mentioned. And so that I guess is the first reason why this paper being launched today is extremely helpful from our perspective. But more fundamentally, I guess why it is so helpful is that the approach it takes strongly supports what is probably the core argument that we advance in our case, and the core issue that we seek to address, because at its heart, our case is essentially about, as I mentioned, protecting the rights of the youth applicants to live in a world where global warming has not exceeded 1.5 degrees. And to put that in the language of the European Court of Human Rights, it's about ensuring that this right is practical and effective, not theoretical and illusory. And as has been pointed out in the literature, if states pursue mitigation measures that are consistent with less stringent measures of their fair share, it will not be possible to hold global warming to 1.5 degrees, or indeed to any collective target. So we argue that in order to ensure the effective protection of the applicant's rights, the respondent states' mitigation measures must be consistent with more stringent measures of their fair share. And we argue that the European Court of Human Rights in Strasbourg is particularly well placed from its vantage point as an international court with jurisdiction over multiple states to see that it's not possible to achieve the effective protection of the applicant's rights if all states choose self-serving interpretations of their fair share. So we've referred in our application, which was filed last year, to the Climate Action Tracker methodology, because we think the way it identifies the position on a country's fair share range that its emissions reductions need to reach in order to achieve the 1.5 degree target, assuming, of course, that all other countries pursue equivalent levels of ambition relative to their respective fair share ranges. We think this is an approach which is very consistent with our overall argument. And of course, that's why the paper we're discussing today is so helpful, because its emphasis on pushing towards more stringent measures in the fair share range adds a very strong additional normative layer to our argument. And it's one which is entirely consistent with the well-established case law of the European Court of Human Rights on the need to interpret the Convention in harmony with principles of international law, including principles of international environmental law. So our response to the government's defences, which we must file by the 12th of January next year, will certainly be hugely strengthened by our reliance on this paper. And the assessments for each of the defending countries will be included in an expert report that is being prepared for us by Climate Analytics, alongside the assessments of the Climate Action Tracker. And I should just finish briefly with a word of thanks to one of the authors of the paper, Gaurav Ganti, who has been very patient in explaining to me the nuances of the similarities and differences between the CAT methodology and the one outlined in this paper. And again, just to say thanks for the opportunity to participate today.
Excellent. Thanks, Gary, also for your remarks. Again, very useful for us to hear that the information that we provide in the paper is used and useful and serves the purpose. That's great. So again, the paper is available on the link that you see on the bottom. Not only the paper, also the results and also the quantitative results for all countries, not only the G20 countries that we showed, but for all countries that we quantified, are in the supplementary information. So if you're interested, you can have a look there. Now it's time for questions. Don't forget your questions. Write them in the Ask a Questions box And if you don't have a question yourself, look at these questions as well, because you can vote for them. And if one is there that you are more interested in than another one, then vote for it, and then it will bubble up and we will get to it earlier than otherwise. So have a question, write it in the ask a questions box and vote for them. All right, and we have already a few of those questions, and let's just dive right into them. And I think you can all see them. I'll start with the top one here, which is this question about fair shares not being own reductions only. For some cases, it is that we've seen that developed countries, they need to reduce their emissions to zero, basically, or negative by 2030. That'll be, in real terms, quite difficult. So one idea is to then, if you can't do it on your own territory, you help others with international climate finance to get there. And so the question is, how difficult is it to precisely compare the ranges you calculated with the actual NDCs? I'm looking at my screen, more looking at Louise, actually, for an answer for that question, if you want. Otherwise, we go there. Louise, is that something you want to take over?
Take a first stab at it. I think this is, you've picked the challenging question to go with, but I think it is an important one. There are things that you can do. I think particularly when it comes to internationally traded mitigation outcomes, that is really emissions. And so then you would have to look at whether the host country is sufficiently supporting mitigation, maybe not just domestically, but also abroad. And there you can actually combine the two. The challenge comes a little bit more with finance. We've already alluded a little bit to the Climate Action Tracker, and that is something that's addressed under that project as well. The challenge there is really, it's how do you convert the finance into a mitigation outcome or a mitigation result. There are some ways to do that, but I think what we can already say very clearly is that climate finance is so insufficient that it can't possibly make up for that gap. The amount of international finance is just so low right now compared to what would be needed to actually get us onto a 1.5 degree pathway, that I think it's just very clear that if a country is not putting forward even what it's putting forward domestically is not going to be particularly added to by that international finance. But maybe others have some ideas on how that can work in a more legal context.
Thank you, Louise. Just to add to what you said, and it's an excellent question from Steve. I think in our paper, we make a distinction, as I said, between principles that are relevant in determining fair shares and principles that are relevant in interpreting and implementing fair shares. And the extent of financial support or capacity building or technology support that's provided to other countries in their quest for reducing their emissions is relevant in implementing fair shares and less relevant in actually determining what those fair shares are. So fair shares are, and we are in this context, in this paper, looking primarily at mitigation. Of course, adaptation and finance and support are very important elements of the overall package, but this paper is sort of restricted to looking at mitigation. And as far as mitigation is concerned, we've sort of looked at principles that help determine what those fair shares are in terms of mitigation. Finance, capacity building, technology support are all relevant in how you implement the fair shares that we have then, once we've determined what those fair shares are. Thank you.
Okay, I think that covers it. Great. And then I would actually move on to a question that is here at the bottom of my list, at least, but has 4 votes, and we almost covered it. It's this: will this paper change the methodology of the Climate Action Tracker? And maybe we should explain that a little bit more, what the relation is between the 2 projects. You want to do that, Louise, or should I? You go for it.
Sorry, I was arguing with my unmute button and the questions. So there is a strong link between this paper and the Climate Action Tracker methodology. Those of you who know the author teams or the CAT teams will recognize names from both places on each one. There are some slight differences. I think Jerry can maybe even explain them better than I can now, but they primarily relate to how we break up. And for example, the Climate Action Tracker has these specific temperature rankings, so you can also look at what would be similar level of effort for 3 degrees, whereas we're focused on this paper in particular on what would be needed for 1.5 degrees. And we have also some slightly different methods in how we determine that emissions level at the end. Other differences are here we present results for all countries, whereas the Climate Action Tracker focuses on 40, but would still have consistent results. So we have the same input data and very similar methodologies and somewhat different ways of presenting the results. But there's feedback between the two to improve them both.
And the other element is that new in the Climate Action Tracker methodology is to look also at the climate finance element. So how much climate finance a country is providing to, if it doesn't make the fair share with their own emissions, whether there is something that it can improve the position by providing sufficient international climate finance. So far, no country has that order of magnitude of international climate finance to step up, but that may change in the future. Good. Other replies to this? No. Then great, excellent. Then I would move to the next question that received 3 votes, which is on the fair share of the US. The US fair share cut looks surprisingly small. What is that? That's the question here. And maybe before I hand over to you, Louise, more on the larger scheme of things. So if calculating a fair share is always dependent on many different indicators that you take in. One of them is economic power, one is historical responsibility, so how much emissions have happened in the past. And the matter on how you do this and how you weigh these different indicators, you get some different results. But in general, it's the developed countries, well, we've seen that they need to go negative, and the developing countries need to also reduce their emissions already by 2030 with some exceptions, but most of them already need to do that. That's the overall scheme of things, and that doesn't change with any method. You can use whatever method you get that kind of a result. And then if there are differences, they are usually in the way the method is done. But maybe, Louise, you can say a bit more about the US.
I think you've made the important points there. I think you may say the US looks small, but I think the US looks small when you compare it to primarily European countries who tend to have even higher historic responsibility. So some studies that go well back in the past, some studies look at historical emissions only since 1990 or 1970, but others go all the way back to 1850. And that's often the studies which then result in even more stringent emissions, particularly for European countries. But as Nicholas said, if you compare the US to maybe other states and particularly to developing countries, they have quite a stringent emissions reduction requirement.
Okay, excellent. There are a few more methodological questions, but I actually want to move to a question that is more related to the court cases here, which is the one at the bottom of my list at least, which is about the credibility of, in this case, the Philippines justice system. And I think it covers a very interesting question, which is that these legal systems are quite different in quite different countries, and you can more or less rely on them. And the question here is how can the international community help to equip local units and courts to ensure adherence to fair share commitments? This is, I think, a very interesting question that I would hand over to those that are really working on this. Any show of hands who wants to cover that question? Lucy?
Sure, yeah. There we go. I think I'm unmuted. Yeah, happy to share some reflections. I think I would say that one of the most positive things that's come out of at least my engagement with climate litigation is how much sharing of resources there is between legal teams and communities that are affected by climate change who want to bring legal accountability in their systems. And I think that's such a strong ethos, and I'm sure Jerry would echo that NGOs at the national level work with NGOs in other national countries, with international ones, and that there's just a real sense of a common effort. Regardless of the differences between legal systems, I think there's a sense that common norms and principles apply, and that there's a real responsibility on those who've had success in their legal systems to work out how they can share that knowledge with others, and to make sure that accountability flows through to other systems. And in the Philippines specifically, I know Greenpeace has done a lot of work with respect to the carbon majors, and that's been a real world first in terms of the inquiry that was launched by their Human Rights Commission, which is it's not a court, but it's a body with a statutory mission to protect human rights. And in that case, we all look to the Philippines as a model for investigating the legal responsibilities of carbon majors for the climate crisis. So I think we acknowledge difference, and we try and bridge those differences through sharing knowledge. Jerry, you've had anything to add to that on your experience?
Yeah, and I think just as, thanks Lucy, just as cases, there's been the positive spillover from cases in one country to another. Our case also very much seeks to build on the cases taken at the national level, but to try and appeal to the European Court of Human Rights vantage point, as I mentioned, as an international court, to try and set a standard that would at least promote collective consistency with the 1.5 degree target if followed by all countries.
Sorry. Yeah, and a related question actually here on the screen was the timing. How long does such a court case take? Because we have no time. Time is running out. We need to have global emissions by 2030, more or less. If a court case takes 5 years, it's too late. How long does it take usually?
Yeah, I mean, I think a good example would be the challenge launched against Germany's overall emissions target for 2030, which was launched by a group of young people at the start of 2020. And then by April this year, so really just a year on, there was a decision from the highest court in the country, which found that Germany would indeed blow its carbon budget well before the end of the century, really in a couple of years, if it was to stay on track. And we saw the outcome of that decision was immediate political action, well beyond what the court had ordered. And so that's an example of really just a 12-month long process. In the Dutch case, the first decision was about 2 years after it was filed. And even though the Dutch government appealed through 2 other levels, it had to comply with the order as it stood. And so we saw action being taken, commitments to close down coal-fired power stations. And so, yes, we certainly acknowledge the long time periods in some jurisdictions, but there are also some positive stories of quick action and quick decisions that have gone through the process. Yeah.
Jerry?
And if I could just briefly add, international litigation is notoriously slow, and particularly in Strasbourg, where cases can take up to, I think, 7 years to reach a conclusion. But in our case, fortunately, we applied for expedition on the basis of urgency, and the court has responded, I think, as quickly as is physically possible in Strasbourg. So the case was communicated, which is the formal step where the court notifies the defendant governments of the case against them within just a little over 2 months of being filed, which, as I said, is about as quick as a case can be communicated. So it is possible for courts, as Lucy said, to respond very quickly. At the same time, relative to the time we have left, it's still, we're over a year into the case yet, and we're still responding to the government observations. But
good to hear that there are shortcuts. Lavanya, you wanted to respond as well?
I actually wanted to ask questions for Lucy and Jerry and jump in these last few minutes. It's absolutely fascinating hearing from the two of you, and you're very much at the forefront of the effort, I think, to sort of bridge the ambition gap through litigation across national and sort of regional courts. The question I had for you both was, what else could we scholars across disciplines be actually doing in terms of producing evidence for these court cases? What do you think the lines of inquiry are that these court cases are now going to focus on, and what could we be doing to help support you in terms of producing that evidence? Specifically, I'm curious about the kinds of questions that might be brought to courts in relation to the long-term net zero announcements and having some sort of, accountability, credibility, and transparency around those, and aligning those with sort of nationally determined contributions that are being put in place that are really not aligned with those not long-term sort of trajectory. So could we be producing some evidence about fair shares in the context of net zero announcements? Also the fairness of those, really, given developing countries may not get to net zero mid-century, but might need a little longer, and others might have to reach net zero much ahead of time, ahead of mid-century, to actually allow room for that. So I'm curious about what we could be doing as scholars across disciplines. It'd be really useful to hear from you both on that. Thank you.
Who wants to take it first?
Okay. Thanks, Lavanya. I think absolutely, in terms of the critique and the challenge to the robustness of net zero commitments, that's absolutely where I think focus will broaden to include that. And we were so interested to see the couple of publications that came out mid-year, I think including from the Oxford Net Zero Project, with the set of criteria, the robustness criteria to use to assess net zero commitments. And absolutely, in terms of the timing of when they should be, because we see in Australia, for example, take just one country, huge debate about whether there should even be a commitment for a 2050 net zero target. And we know in your paper, it's net negative by 2030. So I think having academic and peer-reviewed research, which says these are the kinds of scientific and legal standards that courts can use to assess net zero targets is incredibly helpful, because as much as possible to make these questions not ones of policy or politics, but ones of law and science, I think is crucial. And so having an articulation of standards in a peer-reviewed paper is brilliant. I think fair share in terms of fossil fuel production and exploitation, and an assessment of that is going to be increasingly important. I know that there are some studies that do an assessment of that. And with the production gap report, we again know how big the gap is, but indicating to an individual country what their fair share of fossil fuel exploitation is, I think, is also going to be crucial. Yeah.
Gary?
I was actually just going to mention, partly prompted by one of the questions about contributions of military activities overseas, that one of the things our case seeks to do is to push beyond the territorial limitation of the International Climate Change Framework and to focus on states' contributions to overseas emissions, including through the export of fossil fuels, but also through consumption-based contributions and through the activities of multinational companies which are domiciled or operating in their jurisdiction. And one of the questions, I guess, that I think could be further addressed in the literature is how to tie the overall emissions, both territorial and non-territorial, into a fair share analysis. I think one other point, just to take you up, Lavanya, on the question that I think would be very helpful, would be a slightly more detailed analysis of from a science and law perspective of what highest possible ambition looks like. So drawing on due diligence arguments and also positive obligations under international human rights law to some extent as well, which I guess to some extent are due diligence obligations, and what highest possible ambition in practice looks like would be extremely helpful.
Excellent. I think a lot of work to do for the research community. That's great. Great to hear. We have, 1 minute left, and there's still one question that had 2 votes. I still want to get to that one, which is, will national fair share estimates similar to those in the IPCC AR4 be included in AR6, and why were they not in AR5? That's a very important question, I think. And I've been involved in AR4 and AR5 as well. So in AR4, we basically did this table that Lucy was referring to. That was the basis for the court case in the Netherlands. We just did it basically. It was not meant to be used for that, but now it has been used. And people realized, if IPCC does make a statement of that order of magnitude, it will be used for whatever purpose. And that then in the next round, AR5, we actually also have individual reduction ranges there, but not as simple. No, it was much more complicated per region, for different levels of stabilization. So not as simple anymore. And as soon as it is a bit more complicated, it was not used as much anymore. For AR6, there had been a big discussion whether something is in or not, but it's not out yet. Maybe Lavanya, you can say one sentence on what you think could be in AR6, if you can say anything.
Well, there is not much I can say about it, but I do want to add that I think the sort of sharp distinctions that once were possible between developed and developing countries in the times of AR4 are not now possible in the times of AR6, I think, both for political reasons, because the Paris Agreement tries to step away from those sharp distinctions and binary distinctions. And I think the international sort of negotiating dynamic around those distinctions has now sort of evolved to a stage where it's not going to be possible to actually just say, well, developed countries need to do 25 to 40% below 1990 by 2020. That's not the dynamic that we have right now. So it's not what's going to be reflected in that sense in any scientific reports that come out, because they will look in the way that Nicholas suggested at sort of different groups and coalitions, whether it's regional or others, or World Bank classifications, but not necessarily developed and developing in the binary way that was done in AR4 and was the case with the Framework Convention and the Kyoto Protocol, but is not the case with the Paris Agreement.
Okay, excellent. Unfortunately, time's up. There are still a few questions. I'm sorry that we didn't get to them. You can still reach us. You'll find us and our contact details. Definitely read the paper, download it, take the data. It is on me now still to thank everybody. Thank you as the audience for participating. Thank you, Lavanya and Louise, for presenting the paper. Thank you, Lucy and Jerry, for your great comments on it. Thank you to the Oxford Martin School to organize the whole thing. It was a lot of work and it's working. You can, if you've missed the beginning or want to tell a friend, this will hopefully be on the YouTube channel of the Oxford Martin School. So you can look at this again afterwards and tell others. So thank you all for participating. Thank you very much.